Hello, this is R.J. Deacon reading Supreme Court of the United States Opinion Syllabi. I'm just reading a couple from the 2016 session to keep the feed active, I guess, and last one was Trinity Lutheran, and this one will probably come out a couple weeks from that, and it is Marissa N. Pavan versus Nathaniel Smith on petition for writ of certiorari to the Supreme Court of Arkansas, decided June 26, 2017. It's a per curiam opinion. As this court explained in Obergefell versus Hodges, the Constitution entitles same-sex couples to civil marriage on the same terms and conditions as opposite-sex couples. In the decision below, the Arkansas Supreme Court considered the effect of that holding on the state's rules governing the issuance of birth certificates. When a married woman gives birth in Arkansas, state law generally requires the name of the mother's male spouse to appear on the child's birth certificate, regardless of his biological relationship to the child. According to the court below, however, Arkansas need not extend that rule to similarly situated same-sex couples. The state need not, in other words, issue birth certificates including the female spouses of women who give birth in the state. Because that differential treatment infringes on Obergefell's commitment to provide same-sex couples the constellation of benefits that the states have linked to marriage, we reverse the state court's judgment. The petitioners here are two married same-sex couples who conceived children through anonymous sperm donation. Lee and Jana Jacobs were married in Iowa in 2010, and Tara and Marissa Pavan were married in New Hampshire in 2011. Lee and Tara each gave birth to a child in Arkansas in 2015. When it came time to secure birth certificates for the newborns, each couple filled out paperwork listing both spouses as parents, Lee and Jana in one case, and Tara and Marissa in the other. Both times, however, the Arkansas Department of Health issued certificates bearing only the birth mother's name. The department's decision rested on a provision of Arkansas law, Arkansas Code 2018-401, 2014, that specifies which individuals will appear as parents on a child's state-issued birth certificate. For the purposes of birth registration, that statute says the mother is deemed to be the woman who gives birth to the child, and if the mother was married at the time of either conception or birth, the statute instructs that the name of her husband shall be entered on the certificate as father of the child. 2018-401 F1. There are some limited exceptions to the latter rule. For example, another man may appear on the birth certificate if the mother and husband and putative father all file affidavits vouching for the putative father's paternity. But as all parties agree, the requirement that a married woman's husband appear on the child's birth certificate applies in cases where the couple's conceived by means of artificial insemination with the help of an anonymous sperm donor. See Petition for Certiorari 4, Brief in Opposition, pages 3 through 4. See also Arkansas Code 910-201A. Any child born to a married woman by means of artificial insemination shall be deemed the legitimate natural child of the woman and the woman's husband if the husband consents in writing to the artificial insemination. The Jacobses and Pavans brought this suit in Arkansas against the director of the Arkansas Department of Health, seeking, among other things, a declaration that the state's birth certificate law violates the Constitution. The trial court agreed, holding that the relevant portions of 20-18-401 are inconsistent with Obergefell because they categorically prohibit every same-sex married couple from enjoying the same spousal benefits which are available to every opposite-sex married couple. Arkansas Supreme Court reversed that judgment, concluding that the statute passes constitutional muster. In that court's view, the statute centers on the relationship of the biological mother and the biological father to the child, not on the marital relationship of the husband and wife, and so it does not run afoul of Obergefell. Two justices dissented from that view, maintaining that under Obergefell, A same-sex married couple is entitled to a birth certificate on the same basis as an opposite-sex married couple. The Arkansas Supreme Court's decision, we conclude, denied married same-sex couples access to the constellation of benefits that the state has linked to marriage. Obergefell. As already explained, when a married woman in Arkansas conceives a child by means of artificial insemination, the state will, indeed must, list the name of her male spouse on the child's birth certificate. See 20-18-401 F1. See also 9-10-201. And yet, state law, as interpreted by the court below, allows Arkansas officials in those very same circumstances to omit a married woman's female spouse from her child's birth certificate. As a result, same-sex parents in Arkansas lack the same right as opposite-sex parents to be listed on a child's birth certificate, a document often used for important transactions, like making medical decisions for a child or enrolling a child in school. See Petition for Certiorari, pages 5 through 7, listing situations in which a parent might be required to present a child's birth certificate. Obergefell proscribes such disparate treatment. As we explained there, a state may not exclude same-sex couples from civil marriage on the same terms and conditions as opposite-sex couples. Indeed, in listing those terms and conditions, the rights, benefits, and responsibilities to which same-sex couples, no less than opposite-sex couples, must have access, we expressly identified birth and death certificates. That was no accident. Several of the plaintiffs in Obergefell challenged a state's refusal to recognize their same-sex spouses on their children's birth certificates. See DeBoer v. Snyder. In considering those challenges, we held the relevant state laws unconstitutional to the extent that they treated same-sex couples differently from opposite-sex couples. That holding applies with equal force to 20-18-401. Echoing the court below, the state defends its birth certificate law on the ground that being named on a child's birth certificate is not a benefit that attends marriage. Instead, the state insists a birth certificate is simply a device for recording biological parentage, regardless of whether the child's parents are married. But Arkansas law makes birth certificates about more than just genetics. As already discussed, when an opposite-sex couple conceives a child by way of anonymous sperm donation, just as the petitioners did here, state law requires the placement of the birth mother's husband on the child's birth certificate. And that is so even though, as the state concedes, the husband is definitively not the biological father in those circumstances. Arkansas has thus chosen to make its birth certificates more than a mere marker of biological relationships. The state uses those certificates to give married parents a form of legal recognition that is not available to unmarried parents. Having made that choice, Arkansas may not, consistent with Obergefell, deny married same-sex couples that recognition. The petition for a writ of certiorari and the pending motions for leave to file briefs as amicus curiae are granted. Judgment of the Arkansas Supreme Court is reversed, and the case is remanded for further proceedings not inconsistent with this opinion. It is so ordered. Thank you for listening.